Button, so let's wait for the stream to fire up all across the internet, and then we're going to go ahead and get started. Need to make sure that it is alive and well. As you know, we are multi-streaming here on a number of different platforms, and for some reason it's looking like YouTube is taking a quick minute over here. Let's make sure this is working before we keep going. Let me confirm here with Faith that this looks good. All right, it looks good. My restream is not giving us good numbers for some reason, but she said we're good to go, so we're taking her word for it. Let's get started. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gruler. I am a criminal defense attorney here at the R&R Law Group in the always beautiful and sunny Scottsdale, Arizona, where my team and I, over the course of many years, have represented thousands of good people facing criminal charges. Throughout our time in practice, we have seen a lot of problems with our justice system. I'm talking about misconduct involving the police. We have prosecutors behaving poorly. We have judges not particularly interested in a little thing called justice. And it all starts with the politicians, the people at the top, the ones who write the rules and pass the laws that they expect you and me to follow, but sometimes have a little bit of difficulty doing so themselves. That's why we started this show called Watching the Watchers, so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency back down upon our system with the hope of finding justice. And we're grateful that you are here and with us today. Hope everybody had a nice, lovely, long weekend. Spent a little bit of time reflecting on some of the things that are important to us and our country, really. And got a little bit of time away from politics in there as well. I know that I did. And we're back, though. We're ready to rock and roll. We've got a lot to get into. The Supreme Court came out today. We've got two new opinions that we're going to go through. And in fact, they're not even contentious. Not even something that we have to even fight about. They're unanimous. That means every single judge voted in favor of the final disposition. We have two of those, which sort of reminds me of something that Joe Biden was talking about, my friends, called unity. Are we there? Well, we're going to find out. We've got two 9-0 opinions that came out from the Supreme Court, one involving immigration, one involving native tribal police that we're going to talk about. And we're going to check in with Jonathan Turley. Jonathan Turley, as you may or may not know, is a constitutional scholar, somebody with a lot of brilliance when it comes to these issues. And he's noticing a very interesting trend happening here with the Supreme Court with these 9-0 opinions. We want to see what he has to say about it. And then we've got some warnings from the Democrats out there. If this Supreme Court touches, even thinks about touching Roe versus Wade, there will be repercussions coming. We were going to hear from Senator Blumenthal over from Connecticut, who is laying down what this battle may look like here in the near future. Then we're going to change gears. We're going to talk about that mass shooting that happened last week. Remember this one coming out of Miami? Very interesting, tragic unfolding. We saw that there was a rap concert that was taking place late last week in Miami, and there was a group of, I think, guys, could be individuals, could be females in there, that came upon the concert, jumped out of a vehicle, fired off a bunch of rounds into the crowd as people were leaving the venue, and something like 21 people were injured, 2 people are dead. Then they just hopped back in their car and left. So the Miami-Dade is out now. They're offering tens of thousands of dollars for information about this case. They released some footage of these perpetrators, alleged perpetrators, jumping out of the car, rushing towards the scene, and very little that we can gather from that. They found the vehicle, it sounds like, thrown, I think, in a river, and the guys who did this, who were responsible for it, were completely covered up. So they had masks on. They look like they were very COVID ready, actually. Can't even see anything through there. And, hopefully they find those guys, because something happened here that was tragic. I want to make sure that there is justice. So we're going to talk about that story and see what is going on. And then we're going to talk about what's happening with the FBI, because we have a special agent, somebody with the last name Valdivia, is now being charged with murder. An FBI agent, a special agent, not just a regular agent, a regular FBI agent, a special agent, is now being charged with murder. So we're going to go through that story. It doesn't happen all that often. Apparently this involved shooting somebody in transportation on a subway or something like that. So we're going to take a look at what's going on with that story. And then we're going to talk about a Pentagon police officer who also got indicted for using a shotgun and a pepper spray against a homeless woman. So we've got a lot to get into today. Want you to be a part of the show if you're interested. You can do so by going over to watchingthewatchers.locals.com, which is our separate little platform there where we share content and we connect with other people. And I say this a lot, but every single time that we have somebody sort of leaving the big tech platforms and helping these other newer platforms build, you're helping literally put a brick in the new structure that is going to wash away big tech, hopefully. Now, let's get into the news one more time, watchingthewatchers.locals.com. We also have some links to some other channels down below. I started talking crypto, having a lot of fun with that on a separate channel down. We've got a lot of Arizona content coming out on our R&R Law Group channel. And then we have some live, non-live stuff on my second channel. So go check all of those out down below. And now let's get into the news. All right, enough, Rob. Let's get to it. All right, get to it. All right, I'm going. All right. Supreme Court out today with 2 new opinions. We're going to talk about those. Everybody's sort of scratching their heads a little bit with this current Supreme Court because we were expecting a lot of volatility. We were expecting sort of a bloodbath. We had Amy Coney Barrett that's on there. We have Gorsuch. We have Kavanaugh. We've got all these conservatives. And as we know now, the balance of power on the Supreme Court has tipped a little bit from a more even balance when we had Ruth Bader Ginsburg on there, where it was 5-4. Now, because Ginsburg has been replaced with Amy Coney Barrett, the balance is 6-3. So we've got 6 conservatives, supposedly. It depends where you want to throw Judge Roberts on there. And then we've got 3 liberal judges. But today we got 2 9-0 opinions. It was supposed to be like this conservative wrecking ball going out there and just enacting their patriarchal, heavy hand across the entire country, but that really hasn't happened. And I want to start off, we're going to go through these 2 opinions. Nothing really groundbreaking in these 2 opinions. These aren't anything that we're all going to sort of, fight over, and they're pretty even not controversial, as we can gather from the 9-0 opinion, right? It's kind of obvious that these are the outcomes that they should be, but I do want to go through them quickly just to kind of show you how this works, because we're going to get into a situation very soon where it's not going to be 9-0 anymore. Okay. These are sort of the warm up cases. Supreme Court, okay, 9-0, 9-0, 9-0. Look, America, we can work together. Okay. You don't need to pack the court. We're getting along here. We're moving justice along quite nicely. Then we're going to see, we've got Roe versus Wade coming up on the docket. And so when there is a division there, you're going to hear both sides screaming from the fences that America is crumbling, that justice doesn't work anymore, and that the United States needs to suddenly reform the court by packing the court. And what they're trying to do now, I think both sides, the conservatives and the liberals, is say, hey, listen, we can sort of make this thing work. Just watch. So we're going to go through both cases that came out quickly, and then we're going to take a look at what some of the Democrats are saying about packing the court, because they're sort of the prime movers here. The conservatives, they kind of have control of the court. They have 6 judges up there relative to the Democrats 3, or the liberals 3. So the Democrats really here have a lot of motivation, a lot of enthusiasm about reforming the court. They've already got the White House, they've got the Senate, they've got the House of Representatives. That's not enough, though. So they want the Supreme Court, like any good political party would. And I'm not, faulting the Democrats for that. The Republicans would be doing the same thing if they were in the same position. So what we're trying to do now is just kind of flesh out what the Supreme Court is doing. It's sort of the last battleground state, or battleground constituency, or the last battleground area of our government that we're going to be focused on until the 2022 elections. And so let's go in and start by taking a look at what Jonathan Turley has to say. Here he is. He says here on his blog, which I would definitely recommend adding to your must-read list, he says, today, the Supreme Court issued 2 more unanimous decisions in Garland versus Dye and United States versus Cooley. He says this follows 2 unanimous decisions last week, and this is the weekly I'm sorry, what did I just do here? Let's see here. The weekly decision last week, the display of unanimity is notable given the calls of Democratic leaders to pack the court. Yesterday, I wrote about the heavy-handed campaigns that might backfire with the justices. He says, as we await important and likely divided decisions on issues like abortion, Chief Justice John Roberts and his colleagues seem to be sending a message that the court is not so rigidly ideological as Democratic members and activists suggests. So he said, what Turley is saying here is that the court can play nice. Okay, traditionally we're used to this, blood sport in court and in our judicial system where both sides are killing each other. But here it's unanimous, and he says we had 2 unanimous today, but there were 2 unanimous last week too. So what the heck is going on here? And he's saying it sounds like the court is sort of showing their cards. It's just fleshing out that we can work together, that we don't need any dramatic court reform here, and just let us do our job and things will continue to work as they should. In the Garland case, so here Jonathan Turley gives us a little bit of framing of what we're about to go through with these 2 cases. He said in the Garland case, the court ruled again unanimously to reverse the Ninth Circuit in an opinion written by Gorsuch on the rule that the immigration disputes regarding credibility of non-citizens' testimony, they're sort of talking about this presumption of credibility. So when you're going through the immigration process, there is a well, we're going to get there. We're going to go through the case itself. Let me show you what's happening in Cooley. In Cooley, the court unanimously ruled in an opinion by Breyer that a tribal police officer has the authority to detain temporarily and to search a non-Native American traveling on a public right-of-way. So we've got 2 cases, one involving immigration. The first one that we're going to talk about is the Garland case. We're going to talk about Garland first. Garland is the immigration case. And in this one, we have Merrick Garland, who is representing the Department of Justice. He's the Attorney General, you can see here, versus Dye, all right, which is this person with this last name here. And so this is being filed out of the Supreme Court of the United States. You have a notice here that says, this opinion is subject to formal revision. And so here we have just the basic, in this sort of intro paragraph, says the Ninth Circuit has long applied a special rule in immigration disputes. The rule says that in the absence of an explicit adverse credibility determination by an immigration judge, a reviewing court must treat the petitioning alien's testimony as credible and true. So we're talking about when you have an immigrant who's coming into this country and coming through the process. We don't know anything about that person. And so when they start telling us stuff, the question becomes, from our perspective as let's say Americans who are running a country that want it to run properly, we have people that we don't know where they're coming from who are trying to either immigrate, illegally or legally into the country. They're going through immigration proceedings. We don't know who this person is. And so we've got questions about it. Who is this individual? Where are they coming from? Do they have a job? Do they have kids? Do they have any needs? Are they going to be a net benefit to the country or a net drain on the country? And if so, how do we distinguish what to do with that person? Right? We have a lot of people right now coming across the border and causing a lot of problems for the country. And I want to discuss this with as much humanity as possible. I have a lot of heart for those people. I think that anybody willing to sort of pick up their kids and their family and trek thousands of miles to be here obviously has a lot of love and a lot of intention to be something, be a part of something that's pretty damn amazing in my opinion. But what we're talking about is once they're in the justice system, what happens? They're going to be telling us a lot of things. And as a judge, as somebody who's helping them through the system, we have to ask ourselves, how do we know what they say is true? Are they telling the truth? Is this honest or dishonest? Or what are we supposed to do with this information? Because we know that people have a tendency to bend the truth or to communicate in a way that is not honest. And so what they're talking about is the presumption. When somebody comes into the United States and tells us something, what do? Do we say, well, we're going to presume that everything that you say is a lie, or we presume that everything you say is going to be true? So what we're talking about here is the Ninth Circuit said that there was a sort of a rule that everything must be interpreted as being credible and true. We can see here. At least 12 members of the Ninth Circuit have objected to this judge-made rule, and we granted certiorari to decide whether it can be squared with the terms of the Immigration and Nationality Act. So we have this sort of rule that says, well, unless we have something that says explicitly that what this person is telling us is not true, then we're going to treat this as credible and true, which was sort of the rule, it sounds like, that the Ninth Circuit set up. They said, if they come and they tell you something, the default here is that we're going to believe them. We're going to deem that to be credible and true unless we hear something contrary to that. And the Supreme Court came out and in unanimous fashion, as we can see here, decided, nope, that's not actually how we're going to do it at all. And we've got all of them, all 9 voting against that. So voting to overturn the Ninth Circuit. So you can see here, right? I don't even need to go through the list because it's everybody. And we've got, ordered by seniority. So of course we have the Chief Justice. And then it works its way down to our two new additions in Kavanaugh and Amy Coney Barrett down here. Judge Gorsuch wrote this opinion. Of course, Gorsuch was a Trump appointee. And so let's take a quick look at what is happening in this opinion. So in each of these cases, we have a foreign national who appeared before an immigration judge, said that he does not want to be returned to his country. We have this person had to determine whether he committed a disqualifying, particularly serious crime based on his prior conviction. So we have the immigration court. It says it considered both the probation report that was issued at the time of the conviction as well as his own testimony. There was a serious domestic violence type of proceeding that happened, which included an admission that he hit his girlfriend, but allegedly did so in defense of his daughter. So relying on, in part, on the version of events in the probation report, the court held that Enriquez was ineligible for relief. So he appealed. The Bureau of Immigration affirmed. In Ming Dai's case, he testified that he and his family had suffered past persecution by the Chinese, and he expected future persecution upon return. But Mr. Dai initially failed to disclose that his wife and daughter had both returned voluntarily to China since accompanying him to the United States. When confronted, Dai told, quote, the real story of why he remained in the U.S. The court found that his testimony undermined his claims and denied his relief. So on appeal, the court affirmed Mr. Al Enriquez each sought judicial review in each case. The Ninth Circuit noted that neither one of them made explicitly adverse credibility determinations under the Immigration and Nationality Act. So we've got two people who are here in the United States. They want to stay here. We've got one guy who is Alcarez Enriquez, and so he is sort of being questioned. They're trying to send him back to where he came from. They don't tell us where that was from, but I would guess just based on the name that it's probably somewhere in South America. So he or North America, sort of in Mexico and the southern Central American states. So if he was here, he's involved in a domestic violence incident. He's also got an admission that he said that he did in fact engage in this, and he was doing so in defense of his daughter. So he makes these claims. The court says, it's a domestic violence offense. Can't keep you here for that. That's a disqualifying offense. And so we gotta send you back. Same thing happens here with Mr. Dai. Mr. Dai is a Chinese national, says, hey, I'm in the United States. I'm telling you, I am giving you the statement that if you send me back to China, I'm going to be persecuted. Okay? I'm telling you that. That is my honest statement. And the immigration court says, yeah, but you said that also applied to your wife and daughter, and you sent your wife and daughter back to China. And if you were so concerned about persecution, then, well, why'd you send them back? So we don't buy your persecution story either. And Mr. Dai comes back and he says, well, hey, what does that have to do with, I told you that I would be persecuted. The fact that I sent my wife and daughter over to China, that is not anything that would go against my credibility. That's not anything that would undermine what I already told you. And based on what the Ninth Circuit Court of Appeals has said, you have to give me the most credibility. You have to say that absent any adverse, explicit, contrary information, that you have to believe me. That's what the rule is. And so now we're taking this up to the Supreme Court. And these two people are saying they're trying to throw us out of this country without following the rule that says that they should believe us first and foremost. So what does the court say? Let's continue on with this analysis. It says, held, the Ninth Circuit deemed true or credible rule cannot be reconciled with the immigration statute. Ninth Circuit rule has no proper place in reviewing the court's analysis. They say that the INA, which is the Immigration Naturalization Act, says that it provides a reviewing court must accept administrative findings as conclusive unless any reasonable adjudicator would be compelled to conclude to the contrary. So they're sort of weaving in here what it looks like is another area of law. So they're referring back to this, quote, administrative findings, which they're pulling from this case here, Vermont Yankee, nuclear power versus the Defense Council. They say judicial proceedings in cases like these do not constitute appeals in which the rebuttable presumption of credibility on appeal applies. Here, there was only one appeal from the IJ to the BIA. All right, so this continues on. This makes sense. So here they give us some analysis. For Mr. Alcarez Enriquez and Mr. Dai, they offer an alternative theory for affirming the Ninth Circuit. They say they were entitled to the presumption of credibility because of their appeal. In their appeals, they are entitled to relief because no reasonable adjudicator is obliged to assume their credibility could have been found against them. In other words, they're saying the rule says that we should be afforded the presumption that we're being honest and credible and truthful. That's what the rule says. They're saying here that they told their stories and that they listened to them, and that sort of what they told about the domestic violence offense or about the persecution in China, that's not enough to overcome that presumption. The law says we give them a strong presumption. They told us a little bit. The court said, well, in this case, then you told us something that means we can't give you relief, but they're saying, well, that's not enough. It shouldn't be strong enough to overcome the presumption. We got one more slide on this. The presumption of credibility on appeal under the INA is rebuttable. Okay, and the INA contains no parallel requirement of explicitness when it comes to rebutting the presumption. Reviewing the courts, they say the circuit court considered the possibility that it was rebutted. The BIA expressly adopted the decision. Let's see. The presumption of credibility applies with respect to credibility, but the INA expressly found that the presumption expressly requires the non-citizen to satisfy the trier of fact on credibility, persuasiveness, and the burden of proof. Even if the BIA treats a non-citizen's testimony as credible, the agency need not find such evidence persuasive or sufficient to meet the burden of proof. Here, the Ninth Circuit erred by treating credibility as dispositive of both persuasiveness and legal sufficiency. This was signed off by Gorsuch and delivered for a unanimous court. Right. And so, when you have a 9-0 verdict like this, and it sort of goes against immigrants, right, 2 immigrants who wanted to be here, and they had what they thought was a pretty good claim. We had the Ninth Circuit Court of Appeals that said specifically, hey, this is the rule. As long as there's nothing to contradict what they say, we got to believe them. They followed that rule, goes up to the Supreme Court, and it goes 9-0. Nope, it's not what it says. In fact, you're allowed to go and rebut that presumption. You're allowed to say, yeah, I mean, we can have a conversation about it, and we rebutted it, and they're allowed to talk about, which they did. And now the whole case is sort of resolved. This whole thing is resolved. We don't even have to talk about it anymore. And it was 9-0. What happened if this would have been a 6-3 ruling? I wonder if there would have been more people upset about this. Maybe this would have been framed as an anti-immigrant, racist, whatever, because it goes against immigrants. But now it's 9-0. So we have a lot of cohesion, okay, which is back to my point about the court. Immigration's a big issue. We've got a lot of cohesion around this issue. Let's go to the next case. We have U.S. versus Cooley, right? We're going to go through this quickly again. I know this is heavy lifting, kind of reading through some of this, not my favorite thing to do, but it is, I think, important to what we're talking about here. So let's take a look here at the October term from 2020. This is a slip opinion, which means this could be updated. As you'll note here, the syllabus says, when it's feasible, we're going to give you this stuff, but keep in mind this could be subject to change later on. So this is from the Supreme Court of the United States. This is Cooley versus the United States. And this is a little bit more of an interesting case. This involves some criminal law. So let's talk about this. It says, late one night, we have Officer James Saylor. He's of the Crow Police Department. He approaches a truck parked on the highway. It's a public right-of-way in the Crow Reservation in the state of Montana. So we have an officer, we have somebody who has his truck parked on a highway. It's on U.S. Highway 212, United States Highway, going through the Crow Reservation out in Montana. And so, the reservation is its own land, and we have a road going through the reservation. We have Officer James Saylor now go and approach the vehicle, the car that is parked there. Okay, just framing that out. Saylor spoke to the driver. Driver is named Cooley. He observed that Cooley appeared to be a non-native and had watery, bloodshot eyes. Saylor noticed 2 semi-automatic rifles laying on his front seat. Fearing violence, Saylor ordered Cooley out of the truck and conducted a pat-down search. Saylor also saw in the truck a glass pipe and a plastic bag that contained methamphetamines. Additional officers, including an officer from the Federal Bureau of Indian Affairs, arrived on the scene in response to Saylor's call for assistance. Saylor was directed to seize all the contraband, leading Saylor to discover more meth. Saylor took Cooley to the Crow Police Department, where federal local officials further questioned him. Subsequently, federal grand jury indicted Cooley on drug and gun offenses. District Court granted Cooley's motion to suppress the drug evidence. Ninth Circuit Court affirmed. They said that a tribal police officer could stop and hold for a reasonable time a non-Indian suspect if the officer first tries to determine whether the suspect is non-Indian, and of course, of doing so, finds an apparent violation of state or federal law. Ninth Circuit concluded that Saylor had failed to make that initial determination here. All right, so let's frame this out, and then let's see what the court has to say about this. So first and foremost, we go back to the scene, and what we're talking about here is really a jurisdictional issue. We have the Indian reservation. We have the Bureau of Indian Affairs officer who shows up on scene. We have a number of other officers, and then we have this gentleman, Cooley, who is not a Native American, and he is traveling through land that is within the jurisdiction of that reservation. So we got a question. Well, how does this all work? Can the reservation law enforcement agency exercise jurisdiction and authority and control over that individual? The district court said no, they can't. And they actually granted the motion to throw out all of the drug evidence that was seized by those police. So they filed what's called a motion to suppress the evidence. They said, okay, they charged him. They're moving forward in court. They got some good defense attorneys who said, we're going to file a motion to throw out that evidence. Why? Because that evidence came from an unlawful seizure. It came from an illegal search. The officers who showed up at the scene didn't have jurisdiction over Cooley because he's not a Native American. They have jurisdiction over Native Americans. They're reservation police officers, and he is not a Native person. So what the district court and the Ninth Circuit said is what the police should have done is made the stop, held him for a reasonable amount of time to determine whether or not he also, bring somebody else in to determine whether or not he also violated some other laws, and then prosecute him accordingly. Because they didn't do that, they're saying they broke the law, and everything that came as a result of that violation of the law should be suppressed. It should be thrown out. We call this fruit of the poisonous tree. You can't have that. So as a penalty to the government, because they violated his constitutional rights and prosecuted him outside of their lawful authority to do so because they were in breach of jurisdiction, the penalty goes against the government to make sure that they don't do that again. The penalty for them is, we can't, what are we going to charge them a fine for violating your constitutional rights? No. So we say, you can't use that evidence. We know that you're not going to be able to prosecute him. That's too damn bad. That is your penalty for violating his constitutional rights. And so this was standing. The Ninth Circuit Court of Appeals agreed, said, yep, throw that evidence out. Should have done it differently. What does this court say? And again, this is a criminal law case, right? This is a criminal law issue. The court says, held unanimously, a police officer has the authority to detain temporarily and to search non-Indian persons traveling on public rights of way running through a reservation for potential violations of state or federal law. Right? So they are reversing again the Ninth Circuit and the lower level district court. And once again, this was unanimous. They say, as a general proposition, the inherent sovereign powers of an Indian tribe do not extend to the activities of non-members of the tribe, as a general proposition. Here is how they voted once again, 9-0. We got Judge Breyer over here, who is typically on the left, as you can see from seniority. We've got, this is sort of left, liberal. This is right, sort of conservative. And it's interesting how they have this ordered. Yeah, this is accurate. I would say certainly. I think this whole thing's accurate. We have Breyer here, who is the author of the opinion. We have looks like no dissenting opinions because this was, of course, unanimous. Let's go in and see what's happening here. The court identified in Montana, another Supreme Court case, 2 exceptions to the general rule. And remember, the general rule here is that sovereign powers of an Indian tribe do not extend to non-tribe members. They said, but there are 2 exceptions to that rule. The court identified 2. The second, which almost fits like a glove here, they say, a tribe retains inherent authority over the conduct of non-Indians on a reservation when that conduct threatens or has some direct effect on the health or welfare of the tribe. All right? So they're pulling that directly from another case, U.S. versus Montana. And they say, if it's going to potentially impact the health or welfare of the tribe, you're allowed to exercise your authority. The conclusion that sailors' actions here fall within the second exception is consistent with our cases. Similarly, the court has held that when jurisdictions try and punish an offender outside of the tribe, tribal officers may exercise their power to detain the offender and transport him to the proper authorities. So the rest of this looks like they're sort of buttressing that claim. The court doubts the workability of the Ninth Circuit Court standards, which would require tribal officers first to determine whether a suspect is non-Indian, and if so, to temporarily detain a non-Indian only for, quote, an apparent legal violation, which would be a problem, right? Because that would be an unlawful seizure. So they're saying, all right, so let's go ahead and just say we just applied what the Ninth Circuit said. Let's just say that was the rule. We say, yep, we're going to adopt that rule. And their rule says, well, you're supposed to detain that person and wait until some other officers who is non-native can come in, somebody who's certified, let's say on, U.S. law, to then make a determination about whether or not that person was in violation of U.S. law. And so now you got to sort of hold that person there. And if that person's not in violation of the law, is that a breach of that person's, due process right? Is that an unlawful seizure, a violation of his constitutional right? So the court is fleshing some of this out. Cooley's arguments against recognition of inherent tribal power here are unpersuasive. They said that this case does not raise that concern that due to a close fit between Montana's second exception and the facts here, the court sees nothing in existing federal cross-deputization statutes that suggest that Congress wanted to deny tribes that authority. And they say here, it's a real short intro here, syllabus. To the contrary, existing legislation and executive action appear to operate on the assumption that tribes have retained this authority. Here's Justice Breyer delivering. Alito wrote a concurring opinion, but it was unanimous across the board. And so when a judge writes a concurring opinion, usually what that means, they agree with the holding, they agree with the final outcome, but they may disagree with how they got there, right? So we all want to go to Disneyland, but some of us are going to go through San Diego. Some of us are going to take the I-10. Some of us are going to come from, Seattle down to Disneyland. And it's just about how we get there. So we now know we've got 2 9-0 opinions from the Supreme Court. And this last one, I think, actually, kind of makes sense instinctually. Think about it this way. If you are driving through, in Arizona, we're a very spread out municipality here in Phoenix. We've got Scottsdale, we've got Mesa, Gilbert, Glendale, Peoria. We're spread out massively here. And so when we drive from one end of our city to another, we're going through like 3 or 4 different cities. And so the analogy would be that only Scottsdale police don't have the authority to only stop you and prosecute you in Scottsdale. They do this all the time. They actually do these probably in your cities too. They call them task forces, where they'll have these big conglomerates of a lot of different agencies all work together. We have these DUI task force all the time, and you'll get Chandler, Gilbert, Phoenix, all of them, all working one area. In Arizona, they call it the East Valley Task Force. So they'll go out there and just all, band together and patrol the East Valley. But what ends up happening is you may have a Gilbert cop who stops somebody in Scottsdale, or a Scottsdale cop who stops somebody in Gilbert, and they still have authority to prosecute those cases. Now, the difference here being that they're both in the United States, they're both U.S. citizens, and we sort of give or have agreed that there are sovereignty for Native Americans on tribal lands that are a little bit, protected from our overlapping laws. And so it's a little bit different, but it makes sense. You sort of wouldn't want a situation where you have people going on to Indian reservations and committing crimes knowing that they might be outside the purview of tribal law, right? Like, you have to think about some of these perverse incentives that would be created if you said, yeah, that's fine, you can do that. Then you'd have a bunch of people going onto tribal lands and committing a bunch of crimes knowing that their law enforcement would not be able to necessarily prosecute them until they brought in somebody else who is another officer. So you have these overlapping layers of law enforcement, and it just makes sense. You want law enforcement, I think, to be able to not be so geographically locked. So the point here, less about the holdings, more about the fact that we've got 4 unanimous opinions from the Supreme Court that came out very recently. Let's check back in with Jonathan Turley and see where he wants to go with this. He says, this is an extraordinary litany of unanimous decisions and could, in part, reflect an implied message from the justices that this is a court that is not nearly as rigid and divided as suggested. Recently, Breyer, who just authored that last opinion, warned against any move to expand the Supreme Court. He also rejected the characterization of the current court as conservative or ideologically rigid. Breyer, who is on the left, we saw him. This is Breyer right here. He wrote this opinion. Breyer was swiftly denounced by figures like cable news host Mehdi Hasan. never heard of him, who called him naive, called for his early retirement. That didn't work out with Judge Ginsburg, folks. Judge Ginsburg, remember, there were people screaming at her, you got to retire. Get off the bench. She didn't go anywhere. Didn't work out well for him. Maybe they should change their tune with Breyer here. Demand Justice, a liberal group calling for court packing, had a billboard truck in Washington the next day in the streets of Washington warning Breyer, retire. Don't risk your legacy. Oh, no. Judges do not like that at all. Breyer, retire, don't risk your legacy. Oh, no. I mean, that guy might stick on for another 20 years. Demand Justice once employed White House Press Secretary Jen Psaki as a communications consultant. And Psaki was on the advisory board on one of its voting projects. Oh, that's good stuff. All right, we're going to wrap up with Turley. He says, other justices have denounced such court packing schemes. Shortly before she died, Ruth Bader Ginsburg publicly warned against the move. She said, quote, if anything would make the court look partisan, it would be that. One side saying when we're in power, we're going to enlarge the number of judges so we would have more people who would vote the way we want them to. Ginsburg spoke out against it. Nevertheless, Democratic members have continued to call the court, to use Joe Biden's words, out of whack due to the conservative majority. Senate Majority Leader Chuck Schumer and more recently Blumenthal have warned conservative judges of dire consequences for the court if they do not rule with their liberal colleagues on high-profile cases expected in the next 2 weeks. And we're going to be talking about all of this, of course, but they're really, really concerned about Roe versus Wade. And we're going to talk about the language that Blumenthal uses. He's from Connecticut. In the next slide. Let's see what AOC has to say, though. She says that she not only endorsed the court packing scheme, but went even further to question why we should listen to just 9 people. Such important questions. She appeared to question the very basis of Marbury versus Madison, which is the seminal case, the most important case in our constitutional jurisprudence. This case laid the foundation for the Supreme Court in our constitutional system. AOC challenged, AOC challenged the role of the court in overturning the laws. She questioned, quote, just functionally, the idea that a 9-person court can overturn laws that thousands, hundreds and thousands of legislators, activists, and policymakers drew consensus on. How does the current structure benefit us? I don't think that it does. Because it's a court, because the court has to gauge the constitutionality of what you do, Miss AOC. You're the legislature and you're a legislator in that division of our country. So what you need to do is pass the laws that you think are lawful and that follow the rules of the Constitution. And we don't have to take your stinking word for it. That's what the judge in the court is for. You pass the laws. The executive branch enforces the laws. The judicial branch tells us whether the laws are constitutional or not. We need that as a proper check and balance on our constitutional system here. And it's really annoying to me that somebody who is one of the most loud, let's say, Congress people in the United States with the most followers, the most other people who don't know how any of this works, of all of the elected people out there belittling the court, calling for dramatic overturning of the current structure of jurisprudence, apparently. She's talking about Marbury versus Madison, not... Oh, my gosh, it's so painful. All right, let's take a look at what Blumenthal here has to say. Blumenthal now is getting in on this mix. This story comes over from the Hill. Roe versus Wade blow would fuel expanding the Supreme Court. So Blumenthal here says that the Supreme Court's conservative majority this week agreed to hear a Mississippi case, which would dramatically narrow abortion rights by allowing states to make it illegal to get an abortion after 15 weeks of pregnancy. Blumenthal comes out. He's on the Senate Judiciary Committee. He says it will inevitably fuel and drive an effort to expand the Supreme Court if this, and listen to his language, if this activist majority betrays the fundamental constitutional principles. All right, so let's just break down that statement right there, right? Fundamental constitutional principles. So is he talking about Roe versus Wade? Because if he's ever read Roe versus Wade, you'll know that the court really didn't concoct that case by looking at the Constitution or pulling anything out of the Constitution. Do you know how we know this? Because if you can read it, if you'd like, you can go take a look at the Constitution. It doesn't mention anything about abortion anywhere. And it also doesn't grant the court the authority or the ability to just go and concoct entirely new statutory schemes and then cram them down the throats of the rest of the country. There is a government body that's supposed to do that, and that's okay. It's called the legislature. They're allowed to do that all the time. They can take whatever garbage they want and cram it down our throats all day, and we have to sit here and like it, okay? We have to, okay, fine, because we vote for those people. There's a check and balance on that. We get to vote them in and vote them out. And that's part of the system by design. So if we don't like the garbage that they're feeding us that day, we just say, all right, well, we're not going to be eating that again next cycle. That's for sure. Thanks for playing. You're gone. We don't have the ability to do that with the Supreme Court or with our judiciary. So when our Supreme Court now comes in and does what the legislature does, like, for example, telling us that we have a new structure for how abortion works in this country, in the first trimester, can't touch it. Second trimester, you can sort of regulate abortion. Then in the third trimester, you can actually regulate it, right? You can actually do some things in that third trimester. And many scholars are going, constitutionalists are saying, hey, where did this sort of this three trimester or this three phase abortion approach come into play, Supreme Court? Because that sounds like a legislative bill that the legislature should have passed, not you guys. But for some reason, the court did that anyways. So I don't know where they got the authority to do that, because the Constitution says that should be done by the legislature. And here, Blumenthal is saying that the court somehow was betraying fundamental constitutional principles, I guess, if they're trying to address this in any way, shape, or form, that they are violating the constitutional principles. But I don't know what he's talking about, because they're not in there. It says it's already driving that movement. He said it doesn't mean that a Congress led by Democrats would immediately be able to add justices to the court, but he suggested it would add momentum to reform efforts at a minimum. Quote, chipping away at Roe versus Wade will precipitate a seismic movement to reform the Supreme Court. May not be expanding the Supreme Court. It may be making changes to jurisdiction or requiring a certain number of votes to strike down certain past precedents. No one knows for sure when the Supreme Court will hand down its decision in the Mississippi case, but it's widely expected to hear arguments after it convenes in October. That could set up a decision next year. You know what also happens next year? The midterms. Oh, isn't that convenient? Wonder if this will get pushed out beyond that, or if this will be a new issue that we're going to kill each other over near the end of next year. Let's take a look at some questions over from watchingthewatchers.locals.com. If you want to be a part of the show, that's the place to do that. First up in the house is Software Nugget. What's up, Software? Says Roberts is not really that conservative. Yeah, that's true. That's why I kind of needle Roberts all the time because of that. Love the avatar there. Einstein is in the house. We got Nadar Blasirs is here. Says, so what do you think it says about our lower courts that the Supreme Court has had these unanimous decisions? I feel like the lower courts think they're allowed to rule based on politics rather than actual law, because what's the disincentive? How would you feel about a 3 strikes you're out for a judge? If a judge gets 3 of his cases, his or hers, overturned, they get fired for not following the law, because that's basically what an overturning the decision is, right? You know, judges do not like to be overturned. It's not a feather in their cap. Okay, it's not something that they appreciate at all. So when you take a case up on an appeal and it comes back down, if the judge gets a little bit gets slapped a little bit, you kind of earn a little bit more, I would say, gravitas in that courtroom, and it carries weight. So 3 strikes and you're out. I'm not real sure how you would gauge that. I would say that rule probably already kind of applies. I mean, honestly, in practice, where if a judge has, let's say, 3 ethical problems, or 2 or even 1 ethical problem, oftentimes that's enough to get a judge booted. Standards are pretty high for judges, but I think the more interesting part of your question here, Nadarb, is about just ruling however they want. I mean, the Ninth Circuit, as we saw from today's 2 opinions, got overturned twice today, right? 2 times. So you go, all right, maybe that court needs a little, SCOTUS backhand over there and say, hey, get it in order. What are you guys doing? But we'll see where it goes. There was another point I had on this. Lower courts. Yeah, so my other question on the immigration case was, did they not read the Montana versus U.S. case? Because the Supreme Court said, hey, yeah, we know that's the general rule, knuckleheads, but there are 2 exceptions to that. Here's the case. We ruled on this case in U.S. versus Montana many years ago. So there's 2 exceptions. That one fits. Do your research better before you write opinions. We have Seen and Unseen says, Can we take a moment to enjoy the slow clap for the fact that people from both sides came to a unanimous decision? We can't even all agree that it's okay to like beer. I know. It's a momentous day. You know who I credit for this moment of unity? Joe Biden. That was in his inaugural address, my friends. Here we are, 6 months out, halfway through the year, and we have unity at last. Thank you, Joe. Thank you, Joe Biden. We've got Sherry Quidney says, these unanimous decisions are a little troubling to me. It's a signal of unity, but the only kind of unity possible in this ideologically radically divided country would be for what I call traditional Americans to capitulate completely to the communist element who have taken over all of the institutions of power. What do you think? Well, I'm not, first of all, Sharon, I love that. That's beautiful. It's very dystopian and I love it. I love that. I was watching some dystopian, I was trying to find a good dystopian TV series this weekend. I just couldn't do it. But, I'm not so sort of fatalistic about that. I think that there are a lot of very interesting things happening. I think that there are a lot of, did my audio just cut out? Test. Okay, so that they're sort of bending the knee to a lot of the things that we talk about here on this channel. Woke culture. We see sort of CRT coming around. We see a lot of talk from our government about investigating domestic people, whatever side of the aisle you're on. They're calling them domestic violent extremists. I don't like that for the theory that they're going after the Trumpers or anybody really. I mean, anybody on either side. If they're going to just say that, oh, you're all extremists now because you question the government, that's a problem. Now, if you're somebody who's throwing Molotov cocktails at court buildings, we already have crimes for that. But we're seeing where this is going. We're seeing how, they're sort of using the political behemoth, all of the bureaucracy, to achieve their political ends, which is a scary, scary thing. Fortunately, like I said, I think there are some interesting things happening with technology in other spaces that are going to facilitate more of the slow decentralization of American institutions, which is a good thing. Okay, what's been happening really here for most of my lifetime has been the consolidation of a lot of the institutions of power. We've seen it most thoroughly in my lifetime with the big tech companies, where it went from a lot of different competing entities to kind of the big three now. You've got sort of Facebook, Google, and Twitter, and they kind of control everything. And it took a lot of time, years, almost my entire life, for that consolidation to happen, for Amazon to go from a company that was losing millions to a company that is billions and billions and billions. It takes a lot of effort to get there. And so to see a transition, sort of have to unring that bell a little bit. It's sort of like when you twist your back or you have a sore muscle, it kind of feels like that muscle gets really knotted up, and it happens quickly, right? Just rip, there it is. And what we need to do is unwind that, sort of work that out a little bit. And with technology and with a lot of the pendulum swinging the other way as a result of what we just went through in 2020, I think there is still a little bit of room for optimism, and I'm gonna keep it that glass half full for a little while longer. We have Zuck is in the house, says Indian tribal law seems like a crazy sliver of law. I imagine there's a fair bit of historical precedent most people don't know about. It's strange that the U.S. recognizes another government within the border. Do you know about the origin of why this was allowed, or to have another government authority in the U.S., or do you know what the nature of the first few cases or the legal history there? So I don't, not enough that I would feel comfortable sort of opining about it. I did take a class in college when I was a political science undergraduate that was all about southwestern United States. Obviously, I grew up in Arizona, and I love it here. I've got a lot of history here, and so I know a little bit about, I would say, some of the historical tribes and a lot of the development of southwestern United States from that perspective. But I will grant you that tribal law is an entirely different wheelhouse. We had a lawyer at our firm who actually was licensed in that court, but didn't spend much time over there. And they have their own unique process for all of that. And so I really can't speak too intelligently about it. But of course, the original divergence there was they've been recognized to be sovereigns, okay, by our government. And so we've granted them that sovereign authority. Now, many people have a lot of criticisms about how that all unfolded. And I have no love for the the lack of humanity that has existed throughout American culture, American history. But that's a topic for another day. It is very fascinating, and it is interesting to see how these things interplay with one another, and how we're sort of we have a lot of reservation land here in Arizona. A lot, it kind of surrounds us, especially here in the valley. And so there's a lot of interesting things that happen there with that interface that sometimes I forget that the other parts of the country may not have. All right, so good questions. All of those came over from watchingthewatchers.locals.com. Thank you so much for your support over there. Really does mean the world to us. And so we're going to change gears. We're going to talk about this shooting that happened in Miami last week. We didn't talk about this last week because it was all happening quickly, but we're going to talk about it now. Miami-Dade. The police now have some information about the shooting that took place at the rap concert that was taking place last week in Miami. This was posted by WPLG Local 10 News. They say that 2 people were killed and at least 20 others were injured after police said that 3 people opened fire on a crowd outside a county banquet hall. So we're going to go through this story a little bit. This story is still unfolding. It's kind of surprising at just how much information we don't have yet. But this was a situation where there were a number of people attending a rap concert that was in Miami. And as they were leaving the scene, there was a vehicle that pulled up upon the crowd, and 3 people jumped out of the vehicle, opened fire into the crowd. As we know from this news story, 2 people dead. Now I think the number is 21 total were injured. The people responsible for the shooting jumped right back in the car and took off. Police almost have zero information about them at this moment in time. Let's see what we do know, because it has been a couple days. From Local 10, a little bit of backstory here. You can see that this was published originally on May 30th, so a couple days ago, and then it was updated yesterday on May 31st at 2:48 p.m., and we still have some more updates, I think, that came out today, so we're going to get to those. First and foremost, Miami-Dade police, they're investigating a deadly mass shooting. 2 people dead, 21 injured. They are describing this as a targeted act of violence. And you're going to see what I mean when we get to the video. So quick content warning on this. We're not going to show any footage of anybody dying or being shot, but we are going to see the scene of the 3 people jumping out of the vehicle and then sort of running before opening fire. We don't see any of the gunshots, but we do see them get back into the car and then take off. And the reason I want to play that is because, of course, they are looking for information about this to piece together what happened here. They say that this is a despicable act of gun violence, said Miami-Dade Police Director Freddie Ramirez. A cowardly act. According to police, the shooting took place after a birthday party for a local rapper known as ABMG Spitta, whose real name is Courtney Paul Wilson. Police confirmed that shots were fired back at the 3 shooters and about 100 shell casings were found at the scene. Well, we know now from the evidence that's coming out that there was a return fire from the patrons when these subjects began firing. There was return fire. There's multiple casings throughout the scene that establishes that. However, we don't know at this time who were the shooters that were returning the fire. We don't know that yet. So it sounds like total madness. We have this birthday party for a rapper, ABMG Spitta, who's there. We have these 3 people who hop out of a vehicle, shoot towards the crowd at this party, at this concert event. And then we have people there just firing back also. So it's just a shootout. It's a shootout is what it is. Here we can see from Law and Crime. This was posted yesterday afternoon, Memorial Day. It says Miami police release a video of the banquet hall mass shooting suspects. Distraught father tells son's killer they will burn. So we've got 2 clips that we're going to go through here. We've got one from the officer, who is the Freddie person, who's telling us a little bit more about what they have uncovered. And then we see this grieving father sort of come into the scene and start yelling at the cameras before police sort of escort him out away from the press conference. So we got that video. Then we have the other video that I described previously about the individuals jumping out of the car and then firing and then running back into the car. So let's take a look at some more background here. The Miami police, there we go. The Miami Police Department released a video on Monday, which was yesterday, showing the suspects in early Sunday shooting that left 2 dead and more than 20 people injured. The video shows 3 masked suspects exiting a white Nissan Pathfinder and running towards El Mula Banquet Hall, where they allegedly fired, quote, indiscriminately into a crowd and murdered 2 people gathered for a rap concert, according to Law and Crime. According to investigators, The establishment was hosting a scheduled event, and several patrons were standing outside. The subject's SUV approached the front of the business. 3 suspects exited the vehicle and began shooting indiscriminately into the crowd. Suspects entered the SUV and fled the scene. Judging by the timestamp on the video, shooting took place in a matter of seconds, and you're going to see what I mean. It goes very quickly. Here is what was posted on Twitter today, I think today or yesterday. Miami-Dade police, release of the video surveillance. We are releasing video footage of the vehicle subjects involved in the shooting that occurred in northwest Miami-Dade on May 30th, 2021, left 2 deceased and 21 others injured. Anyone with information is urged to contact at Crime Stopper 305 immediately. And so we're gonna play this here. This is Miami-Dade Police Department. And again, quick content warning because we know what happens after that, but there's nothing really gruesome or too violent about this. You just see 3 people jump out of a car, then jump back into a car. But I wanted just think about the callousness of this. Think about what you have to sort of be doing as a human to think that this is okay. To just get out of a car, just start shooting people. Okay. Not even somebody that you're mad at, just everybody. Well, I'm mad at that guy. I don't like him. He's having a birthday party. I wasn't invited, so I'm just going to shoot everybody who's there, right? It is so cold-blooded that it makes your skin crawl, but this is the reality of our world. So let's take a watch of what is happening here. All right. That's it. So from about 5:35 to 5:42, they're out of the vehicle, right? So there's the car. And let's take a look at, so we've got 3 people, right? Obviously we got a getaway driver. So we've got, you can't even hardly tell almost anything about the, now this person looks smaller relative to the other 2. So maybe a child or female. This person's also smaller. This person's obviously bigger, but he's also in the forefront of the shot. Here's the vehicle. Now, my understanding is that vehicle was just torched. Let's see if we can watch this one more time just so we can get a better glimpse of what happened here. All right, so 29, they're out at 29, 30, 33, 34. So back in the car in 11 seconds, and then they're off, right? So about 11 seconds, probably 2, 3 of actual gunfire. A lot of people dead, or 2 people dead, a lot of people injured. The video shows 2 suspects exiting the vehicle from the back seat, 1 more from the passenger side front door. After the shooting, each suspect enters through the same door that they intentionally left open. Could be the case that a 4th person was the getaway driver, though police have not said as much. The shooting suspects are believed to be males. Victims' ages are from 17 to 32. 17. We have Clayton Dillard, 26, reportedly one of the 2 people who was killed. His distraught father, Clayton Dillard Sr., condemned the killers on Monday during a press briefing. Said, "You all killed my kid," the grieving father yelled. "You must burn. You're going to burn. You hear me? Y'all took something that was given to me as a gift. Whoever did this will burn." Miami-Dade Police Director Alfredo Freddy Ramirez was speaking at the time that Dillard cried out for justice. Ramirez had just slammed the killers for, quote, targeting individuals and at the same time hitting innocent people that have nothing to do with their beef, ruining families, harming mothers who are here today. Yeah, it's terrible. So here is Stop the Violence. This comes from WSVN News. The MDPD director says, "That is the pain that affects our community right there before you." Victim's father breaks down during the briefing. Here's some more information if you know anything about it. So here it is. I know this volume's a little low.
Targeting individuals and at the same time hitting innocent people that have nothing to do with their beef, ruining families, harming mothers who are here today.
You all killed my kid. You must burn. You're gonna burn. You hear me? You killed a good kid for no reason.
And that's the pain that you see. That is the pain that affects our community right there, right before you. That's why together all of us, we must work harder to bring justice to these families who are crying, as you hear right now. Know that the Miami-Dade Police Department will not stop. We will bring justice. Our community is united. Nosotros estamos juntos para salvar esta comunidad. Los actos de los...
All right, so obviously a grieving father. A lot of heartache there. You know, the community, it's a frustrating situation because sounds like zero leads. Let's take a look and finish the article. Families of the two other victims were speaking. Angelica Green said her son had been shot in the stomach. She was one of the loved ones waiting outside the emergency room. He called us frantic, saying he had been shot, that it hurts, and that he loves us. My husband was like, no, stay with us. Her son described the shooters as guys wearing ski masks and hoodies. You never know what it's like until you have something jerked away from you, said Chad Harris, father of a 19-year-old girl. She's in surgery right now. We're just praying for all the victims, praying for all the families. I am at the scene of another targeted and cowardly act of gun violence, said MPD Director Ramirez, where over 20 victims were shot and 2 have died. These are cold-blooded murderers that shot indiscriminately into a crowd. We will seek justice. My deepest condolences. Ramirez said that the $100,000 reward was offered by Marcus Lemonis, host of CNBC series The Prophet. So take a look here what's going on. This is Alfredo Freddy Ramirez, number 3 on Twitter. This is the director of the police. Says, grateful for this contribution. This is our community. We are stronger together. We need our country to step up with information. If you know something, you can remain anonymous. Just call us. So Marcus Lemonis, he's offering a $100,000 reward to help authorities in my hometown, Miami-Dade. Arrest and convict the suspects. Pass it on. He also says, thank you, ATF Miami, for adding another $25,000 to the reward, where so many victims and families were sadly affected by the senseless gun violence. Your support is genuinely embraced. So they are now out there and asking for help in the community. So that is good news. All right, let's see if we have any questions over from watchingthewatchers.locals.com. Does not look like we do. For some reason, my technology does not look like it is syncing up right now. So that is okay. We're going to just continue on and move forward with the next segment. All right, so last segment of the day, we're going to be talking about the FBI. Oh, gosh, we haven't talked about the FBI in a while, have we? So let's take a quick look at what is going on here. An FBI agent, a special FBI agent, has just been charged with murder. Very interesting story. This case has been being kicked around now for some months. Happened back in December of last year, and there is new evidence now that is going to be going forward in a court of law. Let's take a look at this story over from CNN. Here is the picture of the FBI agent charged with the attempted murder of a man on board in Washington, D.C. area subway system. This was posted over at CNN, written by Christina Carrega and Whitney Wild, posted the day, June 1st. So this is the FBI agent. Now, weird case, right? This guy's been around here for a long time. They say he's an FBI agent. He served his community in dangerous and sensitive assignments for the last 10 years. We do not believe there is evidence to support these charges. We believe that once we get the opportunity to have a fair evaluation, he's going to be acquitted. So we know that the Metro Transit Police, they completed an investigation last year, December 21. They turned over all of the evidence to Montgomery County State Attorney for review. Then a grand jury indicted him on Thursday. Warrant was issued on Friday. FBI said in a statement that the Bureau is aware of the recent charges brought by Montgomery County, which is the Maryland State Attorney's Office. They're fully cooperating. They're going to be following this up with an internal review. If he's convicted, he faces up to 30 years in prison for the top charge. So let's take a look at, figure out what is happening here. So this is why he was charged. He shot another passenger during a confrontation aboard a moving subway train just outside of Washington. He was indicted on attempted murder and other counts. Big charge, right? Attempted murder is not something to scoff at. And his name is Eduardo Valdivia, 37. He was also charged with first-degree assault, reckless endangerment, and use of a firearm in the commission of a felony stemming from the early morning encounter 6 months ago aboard a Metro Red Line train. Passenger who was struck was hospitalized with gunshot wounds but survived. So it's an attempted murder charge. Valdivia was booked into Montgomery County Detention Center on Tuesday morning. That's this morning, according to online records and a jail official. After turning himself in, he's expected to appear in court later in the day. No trial date has been set. Law enforcement officials, they've described his actions as an extreme overreaction to a stranger with a history of aggressive panhandling who confronted the agent but did not physically assault him. There's been no indication that the man was armed. The criminal case against Valdivia is the second in recent months involving a federal law enforcement officer in Montgomery, a jurisdiction that's just north of Washington with about 1 million people. We have this other guy now. So the first FBI agent sounds like something that you probably have seen often when you go and use public transportation. You hop on a subway, hop on a city bus, driving around. I used to ride the light rail here in Arizona all the time. I used to ride it to law school, and I used to take the city bus when I was in high school all over the place. And you sort of see the same people on there a lot of the time. The same people asking for money, same people kind of just hanging out on the system, just doing laps around the city. So it sounds like this special FBI agent went in there and saw this person, some sort of altercation happened, and he pulled out a firearm and shot him and is charged with attempted murder, assault, reckless use of a firearm, reckless endangerment, and some others. Now, what's interesting is this came out of a grand jury proceedings where another officer was indicted out of the same county for a separate case, a whole separate set of circumstances, but out of the same county, same prosecutor's office. And so whoever the reporter was here that said, we're covering this case, they just got a second, buy one, get one free kind of. We have on April 29th, we have an off-duty Pentagon police officer. This guy's name is David Dixon. He's indicted on 2 counts of murder and 1 count of attempted murder. What? Prosecutors say Dixon shot at 3 men in Tacoma parking lot as they drove away and posed no danger to him. So this guy is a police officer at the Pentagon. Okay, the Pentagon is obviously an important place. Dixon's lawyers at a bail review hearing on Thursday said the officer acted in self-defense after the car had driven him and had driven toward him. He's scheduled to be on trial on September 27th. So they drove away and posed no danger. He's saying that the car had driven towards him, and so he had to shoot in order to defend himself, allegedly. Both incidents were captured by security cameras in the parking lot in the Dixon case and inside the train in the Valdivia case. So wouldn't it be nice to see those 2 videos? We've got full footage of the FBI agent shooting that guy, and then we have the homeless person, and then we have Dixon here shooting the people in the vehicle, apparently driving away from him. He says differently. Since launching their investigation of the agent after the December 15th shooting, the FBI and Montgomery County State Attorney's Office have said little about how and why the shooting transpired, other than indicating it was a verbal exchange and confrontation preceded the gunfire. Most comprehensive account was recorded a 911 call that was released by the county officials after a public records request. So we have 2 police officers, 2 law enforcement officials that are being charged with some pretty serious crimes like murder and attempted murder. And we want to get some information about what happened here. FBI and the Montgomery County State Attorney's Office being a little bit quiet about this, not telling us really what happened here. Why is it important that we know what happened here? So that we can make sure that they are being accountable for their actions. Because what oftentimes happens here, as we know, the details are kept behind closed doors. We don't learn about these things until many months after they've happened, as happened here. And then when the formal inquiry starts, there's an investigation that takes place. Officers go through their formal reprimand or whatever procedure. Everything gets swept under the rug. Nobody knows about it. Right back to business. Well, now these are in the news. These are serious charges. These are attempted murder charges. And when journalists and people want to get more information about what happened here, they got to go and get it through a public records request. And they're being very quiet about everything that happened. According to a 911 call placed by another passenger who saw the encounter, the agent was confronted by a man and warned him to back away. The man instead prepared to fight him, according to the call. The FBI agent said, "Move away. I'm an FBI agent. Back away," the caller said. The other gentleman didn't, dropped his bag, approached him to fight him. The agent fired 2 or 3 rounds, according to the witness who called 911. The account did not disclose what was said before the shooting. This is what happened with the Pentagon officer. So this was back April 2021, so just about a month ago. Pentagon police officer accused of shooting 3 men now at a Maryland parking lot. They drove away. He's indicted on 2 counts of murder, single count of attempted murder. Grand jury also indicted Dixon Hall on assault counts for an unrelated incident last year where he allegedly pointed a shotgun and discharged pepper spray at a homeless woman. Okay, so this guy got indicted on 2 different counts, one for an incident last year and then one for more recently. Taken together, all of the charges on Thursday exposed Dixon, who was off duty at the time of the incidents, to a possible sentence topping 200 years for one police officer. An attorney said he's going to plead not guilty to all of them. Mr. Dixon, said his attorney, has been honorably serving the public for 20 years, including 8 years in the military with tours overseas. He will vigorously contest these charges. The main case against him stems from an encounter at 5 a.m. on April 7th. He was leaving his 7th floor residence at the Tacoma Overlook condominiums in his civilian clothes, headed for work at the Pentagon, according to police. In the dark parking lot, he noticed a car with no headlights on. He went to check it out. Of course he did. As he drove up, police said he saw one man outside the car trying to break into another car and confronted them. Video surveillance, according to the documents, captured what happened next. With all 3 men now inside their car, they drove off, and Dixon fired several rounds from behind the fleeing car, according to the documents. Quote, no longer presented an immediate threat that would have justified the use of deadly force. One of his rounds entered the upper back of Dominic Williams, 32, who was in the back seat, according to police. Another round entered the upper back of James Lionel Johnson, 38. He's in the front passenger seat. Driver Michael Thomas drove them to Prince George Hospital Center as they lost consciousness. So this guy over here, David Hall Dixon, just starts blasting through the back of a car that's driving away. So this is him right here, facing multiple charges, several different incidents. In the documents released in April, the Tacoma Overlook Condominium Board of Directors said it sent a copy to the Pentagon. New charges filed in the lobby case prompted the Pentagon to take a look at it. We have Jacqueline Yost over here, who is their spokeswoman. She declined to say whether the agency had indeed received and reviewed the video. First indictment on Thursday charged Dixon 7 counts, 2 counts of murder, counts of attempted murder, first-degree assault in the shooting of Thomas, 3 counts of the use of a handgun during the commission of a felony. For counts related to Thomas, those charges could be merged. He could not be sentenced for both counts. So we got some law enforcement officials going through the justice system themselves. Isn't that interesting? Let's take a look at some questions over from watchingthewatchers.locals.com. First up is Besemiento says, very first thing a new president should do in 2024 is fire the top 25 FBI officials. Corruption there will never change until all the agents are scared. Yeah, I mean, honestly, I don't even know. Yeah, I don't want to anger the FBI or anything like that, but they're basically, I don't know what they're doing. Go on their Twitter, and you can see what their efforts are focused on. Grandma who went in through the Capitol building, and that's about it as far as I can tell. Last question of the day comes in from Jeremy Matrita. Says, aren't the laws for the use of deadly force based on officers' perceived threat? How is it possible for anyone to argue against another person's perception in the heat of the moment? Yeah, it's a great question, right? And so, Jeremy, what we're talking about here is sort of the difference between a subjective interpretation of events and an objective interpretation of these events. We spent a lot of time in the Chauvin trial talking about this and sort of trying to flesh out the difference between the two. If you are an officer at the scene, right, you've got a lot of abilities to perceive other things that people who are watching through a cell phone don't see and can't interpret. And so what we do is, as the law, is we identify what we call the reasonable person, a reasonable officer, a reasonable lawyer, a reasonable doctor, and it's sort of supposed to be the objective version of that. We say, okay, if we just took a reasonable person and shoved them in that position, what would they have done? And then we measure their conduct against that conduct versus, and yet you sort of have to do that, right? Because how could we possibly prosecute people if we applied their subjective interpretation to everything? So like, let's use a self-defense case. What happens if you are somebody who is very, very concerned about being attacked late at night at a grocery store. And so you're walking your groceries out to your car. You get in the car and somebody says, "Excuse me." And they're standing right next to you. And you go, "Oh my gosh, they're going to attack me." And you pull out your gun and you shoot them dead. Right? And we say, well, that's not reasonable at all. No objective person would do that, right? There's nobody in this world, no reasonable person in that person's position would pull out their gun and shoot them. And so that person would be charged with manslaughter or attempted murder or whatever. Now let's say that we don't use that objective standard anymore. We say that whatever you were feeling, your subjective interpretation of the events is the law that we're going to use. And so that person, man or woman, whatever gender you want to ascribe that person, if they say, "I was scared for my life. I thought that person was attacking me. It was 9 p.m. Okay. It was dark out. I couldn't see anything. I'm scared to death out here. He came up. I didn't know who he was. And I thought he was going to kill me. And he said something scary. I couldn't hear it quite. So I shot him." And what if we as a society said, "Well, you heard her. You heard from the lady or from the guy. She's scared to death. So they thought she just did what she thought was right. Had to shoot him." And so, then what kind of legal system would that be? Everybody would just go around shooting each other and saying, "Well, I thought he was going to kill me. Sorry. He cut me off. He deserved it." So we ascribe this or apply this objective person standard so that we have some more concrete rules when it comes to fleshing out these legal issues. And so when it comes to the police, it's got to be a reasonable standard, right? They can't just say, "Well, I was just personally scared. I thought that bum was going to kill me." Well, was it reasonable? I mean, was it reasonable for you to think that or not? Because if it's not, then your use of force is not going to be justified. So good questions. Thank you for all of those that came over from watchingthewatchers.locals.com. Quick reminder, if you want to sign up to be a part of the show, you can do so. Angie _ has done it, and want to welcome Angie to the community. The place where you can sign up is down here, watchingthewatchers.locals.com. And hello, Angie. Thank you so much for joining up and being a part of the crew. Thank you to everybody who asked questions today. Once again, these came over from watchingthewatchers.locals.com. If you want to join us over there, you can. A lot of good things to download, things like a copy of my book. It's called Beginning to Winning. You can download a PDF version for free, or you can buy it on Amazon if you go over there. You can download a copy of all the slides that we went through. We'll share the impeachment party documents. That's available. You can download a copy of my existence systems productivity template. Share links throughout the day and meet great people. There's a lot of good stuff going on, including our next monthly locals meetup coming up on June 26th. We just had one on May 22nd. So our next one is June 26th. It's free to all of our local supporters. If you want to join in on that, it's going to be a lot of fun. Also free Saturday, June 12th. So a couple weeks out, we have our law enforcement interaction training, which is going to be Saturday, June 12th from 12 to 2 p.m. Eastern time. We're going to do this on Zoom, and it's going to be fun. I'm actually excited about this. It'll be a fun thing to do in this format. And I'm looking forward to it. I hope you can join us. And of course, that is for free. Again, if you're at watchingthewatchers.locals.com. And then lastly, before we wrap up, I've got a couple other channels. I would love it if you supported us over there. Down below, we've got links to our R&R Law Group Arizona channel. We have a crypto channel. We're talking about some of the Watching the Watchers components towards cryptography. So we talk about what they're doing with regulation and a lot of the interesting things that are happening with decentralization, having fun on that channel. So I would encourage you to go support us there. A couple others down there if you want non-live recorded content, and other great links down there. So thank you for supporting us. Lastly, before we wrap up, I am a criminal defense lawyer in Arizona. We offer free case evaluations. If you happen to know anybody in the state of Arizona who has been charged with a crime, we would love the opportunity to help. We can help with things like DUIs, drug offenses, domestic violence, anything and everything in between, any offense. If anybody's been in trouble with the law before, we can help. We can clear up old records. We can remove mugshots off the internet, quash old warrants. There's just a lot of work that we can do to help kind of move things back in the right direction. And so if you happen to know anybody in the state of Arizona who needs a little bit of help and support in this space, we would love the opportunity to speak with them. Make sure that they leave our office better than they found us. And that, my friends, is it for me for the day. We're going to be back here, same time, same place tomorrow for yet another show. And it's going to be at 4 p.m. Arizona time, 5 p.m. Mountain, 6 p.m. Central, 7 p.m. on the East Coast. And for that one Florida man, everybody, thank you so much for being here. And I want to wish you a tremendous evening, a lovely restful night's sleep. I'll see you right back here tomorrow. Bye-bye.